Why the Bentham is considered as a father of modern philosophy of jurisprudence? Because he has given a huge contribution in the field of modern lawmaking. The very essential part is that he has provided a method of constructive thinking. Constructive means we have to add something to the existing system. That is a constructive. We have to build. We do not want to destroy, but we want to build a constructive, a positive things for the society. The constructive thinking, that is innovative thinking, he is known for his zeal, his passion for legal reform. Zeal means a passion, enthusiasm for legal reform, and therefore he changed the whole European jurisprudence, especially the English jurisprudence. His important contribution can be said that he has developed a relativist tendency which developed the sociological jurisprudence. Sociological jurisprudence means he tried to relate the law to definite social purposes. He tried to relate means why we want to make a law. We want to make a law in order to balance of interest. We want to satisfy the need and interest of different classes, different sections of society, and therefore the law should have that quality that it can satisfy the wants of different social strata. Okay, then he said that the law must be related with the definite social purposes. Means the law should find out, the law should investigate the social needs, the social situations, and accordingly the law should mold itself, that is the social transformation by law. The subject which you are studying is the social transformation. What is social transformation? The law must satisfy the social purposes. The law must seek the balance of conflicting interests in the society. Then the Bentham has said that there is a need, and therefore he just not only recognized, but he also developed the technique of lawmaking. He said the lawmaking must be a conscious one, deliberate one. There should be certain base, there must be true spirit to make a law. To make a law, you must have certain techniques, you must have that conscious application of mind. It is not just for the sake of convenience, but it is for the benefit of social purposes. You must make a law. The law making process must be conscious, it must be in true spirit. What is conscious? It must be in true spirit, it must be deliberate, there must be an honest effort, there must be honesty in making a law. And therefore, his important contribution to the Europe, to the England is that he said the legislation is one of the important method of lawmaking. It is not the king, it is not the nature, it is not any religious scriptures which can make the law, but it is the legislation, it is the representatives of the people, it is the sovereign who can make the law, and to make the law it is necessary to have legislative body, to have the institution which can make the law, and therefore legislation, that is law making body, law making authority, is the important method of law making. There are other methods of law making. He accepted that there are convention, judicial decisions, administrative law, assemblage of signs, he said. But apart from these, the legislation is one of the important instrument, one of the important institution to make a law. And how that law can be made, we have seen that the 8 respects of law means there are certain criteria, there are certain scientific principles. These scientific principles must be followed in order to make a good law, the law which will satisfy the condition that it should be jurisprudentially analyzable. Further, he said these certain scientific principles of codification, that is the art of lawmaking, the principles of lawmaking. These principles must be applied by every country, every country can take recourse to these scientific principles in order to make the law. Though there are certain national and historical differences in between those countries, प्रत्येक देशामध्ये काही नॅशनल आणि हिस्टॉरिकल डिफरन्सेस असतात. फॉर एक्झाम्पल, द फ्रान्स has a different national and historical differences with the rest of the Europe. The England, America has a different national and historical background than that of India. India has its own historical and national differences with the rest of the English jurisprudence. But still, irrespective of these differences, you should keep these differences aside. You should just follow the scientific principles of codification in making a law. If you do follow these kind of scientific principles, definitely your law, the legislative law, will be good one. It will satisfy the social purposes and it will secure the balance of interest. In this way, we can see these are the important contributions of Jeremy Bentham in England. This has created a huge impact on all the legal systems where the England has its rule. Means in all the Commonwealth countries, these jurisprudence, this philosophy of Bentham has created a huge impact. For example, in India also we have adopted the English common law legal system, under the Westminster model, where we have built on the representative forms of democracy, and where the sovereignty is attached to the parliament. The parliament is nothing but a law making authority. In this way, the Bentham has created his impression on all the contemporary era in modern times.